Sure it's a laptop or something.
I'll leave it in the middle in case you want.
Wait, it's just Mack. I know. I wouldn't hear what was going on with you.
Get ready to get started.
Ready when you are.
Hi everyone, my name is Colleen Freeman. I'm the ACEDS president of the New England chapter, so I wanted to welcome you all to our event this afternoon. We're very pleased to have you here, and we have a great discussion planned for you around GDPR, the Cloud Act, and data privacy concerns. I also have a number of thank yous that I would like to share with you today. First, we're very pleased to have our leadership from ACEDS National here. So we have Mary Mack, who is our executive director. She's also a thought leader in the industry, so we're pleased she could join us and participate on our panel. We have Kaylee Wallstad, who is also on our ACEDS National team. She's been a huge supporter helping us with all of our promotion around the event. And we have Katie Saylor, who's on our national marketing team. She helped also with a lot of the promotions. So feel free to reach out to any of our members here from National after the event if you'd like to learn more about ACEDS and if you'd like to get involved in our chapter or at the national level. We also wouldn't be able to put on this event without the generosity of our sponsors. So we first would like to thank Xtero. They're a gold affiliate partner of ACEDS, and we have Craig Carter in the room. So if you'd like to connect with him afterwards, he's available to talk to you. We also would like to thank Q Discovery. They've been a huge supporter of our local chapter, and we have Brian Dillon here in the room as well. And then we also have a very special dessert sponsor. So thank you to Brian Moretti in Compliance and Brian's aunt who made very special cupcakes. Although we have one disclaimer, one of the types of cupcakes are margarita cupcakes, and they do have alcohol in them. So we just want to put that out there in case it's something that you don't want to have tonight. And then last but most importantly, I want to thank all of our speakers here today. David Horrigan, who is on our board, will be introducing all of the speakers, and without their volunteer efforts and their participation, we also wouldn't have this event. And I don't want to be remiss and forget to thank my entire board. I have all of the members here that have worked very hard to put this event together today. So I will call them out by name. David Horrigan, we have Mike Swyatoka, Kamal Gadalhak, Seth McGaw, and Tom Dwyer. So again, thank you to the board for all that you do. And I hope you'll enjoy our event this evening. We do have a raffle. If you haven't thrown your business card in yet, we're giving away an ACEDS certification. We are one of the, as far as I know, the only accredited certification in the electronic discovery industry. And so we encourage you, if you haven't had a chance to talk to us about signing up for the certification or studying for the test, we're very happy to provide support around that. And again, we have a lot of membership materials outside, so if you haven't already considered joining our chapter, we're very welcoming. We love new members, and I think you'll find that we have some fantastic programming coming up for the rest of the year. So again, thank you for coming. We hope you'll stay for the reception afterwards to do some peer-to-peer networking. And at this point, I'll turn things over to David.
Good evening. Thank you very much for joining us. And my apologies that we did not give you the margarita cupcakes before the presentation so you could enjoy them even more. As Colleen said, I'm David Horrigan. I'm the eDiscovery Counsel and Legal Education Director at Relativity, and I head up our legal education program where we put together programs such as this, and we are partners with ACEDS, and so we are very proud to be here this evening. When we put this session together, we knew that many of you have seen and heard GDPR ad nauseum. And so we didn't want to put together just another GDPR session because the GDPR doesn't occur in a vacuum. Data privacy law is complex, but in reality, a lot of the concepts are pretty simple to grasp. It's just the regulations, the politics, the economics, and the business interests that go back and forth and make a document something that is open to a lot of interpretation. And although the working group, the Article 29 working group, has done some advanced interpretation, we all have to realize that the GDPR is only a couple of weeks old, and so there is an absolute dearth of interpretation of it. But as I said, it doesn't occur in a vacuum. United States v. Microsoft was another long legal saga that came to a stunning and unexpected conclusion with the passage of the Cloud Act. So we're going to talk about all three of these, as well as make a brief visit to the e-privacy regulation. If you hadn't had enough of the European Union regulations, wait, there's more. But first, I'd like to introduce the panel that we've got. You've already heard from Colleen. You've already heard from me. Our first speaker, and by the way, they are in alphabetical order, is Sean Kelly, who is Senior Director at FTI Consulting. FTI is no stranger to e-discovery, neither is Sean Kelly. Before joining FTI, he was with Johnson & Johnson, heading up e-discovery there. And Sean's role today is to be our information governance go-to guy. He has advised companies of all various shapes and sizes and different business verticals on the e-discovery process. And so when you've got questions about how it's going to work from the corporate angle, Sean Kelly is your guy. Please join me in welcoming Sean Kelly. Next is John Koss, Special Counsel at Mintz-Levin. John is one of the boomerangs. He had one tenure with Mintz-Levin, went out and came back to Mintz-Levin as Senior Counsel in Discovery. This is a great setting for Professor Koss, and I say that because he is an adjunct faculty member teaching here e-discovery. He has also taught at his alma mater, the Boston University Law School, where he has taught legal writing, and I believe e-discovery as well there? Or legal writing?
They're not as open to the e-discovery as Suffolk is, unfortunately.
Noted. Note to the audience, Suffolk Law School, progressive, dynamic, high-tech, yay Suffolk. Not to besmirch John's alma mater, but please join us in welcoming John Koss. Next, we have Mary Mack. As Colleen has mentioned, Mary is the Executive Director of the Association of Certified E-Discovery Specialists, ACEDS, and Mary has had a long and storied career in e-discovery. Not only has she been the Executive Director of ACEDS, she has been a vital part of more than one e-discovery company. With Theos, she was a trendsetter. She also has international experience being a senior member of the team at Zylab, based out of the Netherlands. She's going to give us an international perspective, as well as a perspective of some of the members of ACEDS across the globe who have dealt with these issues and dealt with data privacy on an international stage. Please join me in welcoming Mary Mack. And finally, to use the trite expression last but certainly not least, it's a real personal privilege to introduce Alan Pell-Sharp. It's always nice when your old boss says he will come and join you in a speaking event. Alan and I were colleagues together at 451 Research. At 451, Alan was the research director for social business as well as other initiatives at 451. He is a well-known industry analyst. He has been quoted by many, many major media sources. He has been with, in addition to 451 Research, the international analyst firm Ovum. He has been with other analyst firms, and he now is the founder and principal analyst at Deep Analysis, the advisory firm based locally. Please join me in welcoming Alan Pell-Sharp. You'll see our agenda on the board today. We have got a discussion of United States v. Microsoft. And by the way, that name has changed a few times. It started off as NRA Warrant. It changed to Microsoft v. United States because Microsoft appealed. And then when it finally got to the Supreme Court, it flipped again because it was the government who was seeking certiorari. We're going to have a discussion about Microsoft and the Cloud Act. But I would say the major portion of today's presentation is going to be on the GDPR, if for no other reason that United States v. Microsoft, as we've said, went out with a whimper, not a bang. It was sort of a thud as the Cloud Act was passed, basically Microsoft and the government agreeing that the case was then moot. We'll then go into a quick discussion of the e-privacy regulation, as well as some thoughts on best practices and some takeaways. And also, we want to keep it interactive. We're here for a discussion. If you've got any questions, please feel free to ask them, and we'll do our best to address them. How the email worked in Microsoft. First of all, just to get an idea, how many of you are familiar with the Microsoft case? And this is just to ask you how quickly we should go through this. Okay, so we've got a fair number. One of the issues in Microsoft was the fact that data are stored in different places in Microsoft's various email systems. You've probably seen cases that are similar on point like this with the Google system. Google's system for Gmail and other Google assets uses a shard system where the data can be located in different countries at the same time. Basically, different data from one email can be in multiple places. Microsoft's is a little bit different, where they house data in various data centers, but the content was all there. And Microsoft and other companies are no stranger to government data demands. This is a case that involved those data demands. You can see in this map where the data centers Microsoft has are located all over the world. The one that was important in this case was the Microsoft Dublin data center. What you have is two competing theories on how this case should go. One is the prosecution side, where the prosecution is arguing, wait a minute, we were involved in a game of whack-a-mole here. Because the idea is that Microsoft sought a warrant under the Stored Communications Act. And you see warrant in quotation marks. The reason for that is that a warrant under the Stored Communications Act, a law that everyone agrees is a somewhat antiquated relic of a bygone era, passed in 1986, part of the Electronic Communications Privacy Act, it did not envision anything that's going on today as far as cloud computing and the proliferation of email and digital data. So under the Stored Communications Act, prosecutors were entitled to seek a warrant, which is a hybrid between a warrant and a subpoena in the classical sense. The prosecutors in the warrant, again, here's the other side of the story. If you are going to get data from that Microsoft Dublin data center, there was a giant outcry. Should U.S. government law enforcement be able to go to a sovereign nation and collect data? Now, where the data being collected, what's going on with it is an entirely different story. And this is the warrant that Judge James Francis IV, the U.S. magistrate judge recently retired from the Southern District of New York, issued in 2014. And Judge Francis sided with the government on this case, arguing that under the holding that under the Stored Communications Act, that the government was entitled to get the data. And the question really was, as you can see from the warrant, information associated with a specific web-based email account that is, in quotation marks, stored at a premises owned, maintained, controlled, or operated by Microsoft Corporation, a company headquartered at 1 Microsoft Way, Redmond, Washington, I should say. That gives you a little bit of the background on the debate that goes on here. Should the US government be able to go get that data? And is there an issue, on the other hand, of whack-a-mole? Prosecutors argue, if we can't go and get this data from a US company subject to US law, they're just going to move the data around the globe to different data sources, different data centers. We'll never be able to get it. It's a law enforcement nightmare. We'll get into some of the specifics in a minute, but we set the stage for you for a real privacy debate. Alan Pell-Sharp, you have advised international companies. You've been an industry analyst in both the United Kingdom and the United States, and you've got a global feel for what's going on in the globe. What was the international reaction among people to whom you spoke about this case and just data privacy in general?
It's really interesting. I mean, so first a disclaimer, I am not an attorney, so don't pick me up on any legal whack-a-moles that I pop up. But the bottom line is, I think, just from a cultural aspect, and I think this is an area that people don't really look at enough. In the UK, for example, but I think, to be fair, Europe as a whole, there is, forget the law, there is an expectation of privacy. You buy a house, you put a fence around your yard. That's the first thing you do. That's mine, and I build a big hedge. You can't see into my house. Here, we don't live like that. In the US, there's no real expectation of privacy. And it really plays out. I mean, with the Microsoft case in particular, I think it was particularly interesting there because, yes, there was certainly some cultural clashes of, the Americans are coming to grab our data. But it did spark a much bigger debate, which I think played into the whole GDPR situation of, well, I mean, in the technical world, it certainly sparked a debate about what is cloud computing. I don't want to get too technical on this or anything, but, there is no actual cloud. And Microsoft doesn't actually store it. There isn't an it. It's data. It's all over the place. And you can't go and find a specific server in a specific location. It doesn't really work like that. So I think it sparked a whole discussion about data privacy, who owns it, should they own it? Should I be compensated for you making money from my data? I mean, those are kind of discussions that are going on in Europe now. It's way beyond GDPR. Over here, which is where I live, I'm just fascinated. The other week, I won't name names here, but I was in Chicago working with some major insurance companies. And I kid you not, somebody asked me, a very senior person, about GDPR. Should they be doing something about it? I mean, yeah, I guess so. You really probably should. I'm not the person to ask, but I mean, they just haven't taken it. A lot of American firms have just ignored this. They've done nothing, absolutely nothing about it. And I fear they are going to get bitten.
Before we come back to Mary, let's go to the other side of the table. Sean, you advise a lot of companies. FTI's got international reach. What are you seeing as the reaction to data privacy in general, and then perhaps the GDPR specifically, and throw some Microsoft in there too?
Yeah, thanks. I think much like Alan was saying, there's really no expectation here with respect to privacy. We're starting to see that shift a little bit on the state level, but not enough to really drive corporations to action. The companies that I've worked with who have been proactive in their approach to compliance with the GDPR are mostly companies in regulated spaces such as financial services or pharmaceuticals, where the turnover figure could be quite significant to their bottom line, and that's kind of what grabbed their attention. But other than that, we've seen a lot of the let's wait and see. Is the bite as bad as the bark? So I think largely, much like Alan said, it's wait and see.
John, you're advising clients, and obviously Mintz 11 has a lot of global clients. What are you seeing as far as data privacy in general, and is there a level of concern?
Well, everyone's scared, S-list about GDPR, and then I think we talk all about GDPR, but people don't talk as much about Asian privacy regulations that are coming into play and really developing. We're dealing with South Korea right now, and it kind of makes GDPR look like, a leaflet to be kind of reviewed and cast aside. So, it really is becoming its own practice in dealing with international data issues. I think part of the challenge, even intra-company, is that American litigants and even, our clients, they kind of understand a broad-based discovery approach. No one here is surprised, no lawyer, and not a lot of the, senior executives we work with are surprised when we say we're going to collect 100 email boxes, or we're going to go back to 2011 and do up to present of all of the documents on the various employee shared drives. That doesn't bat an eye most of the time in a big litigation in the United States, but no other country has ever heard of this. Discovery in Europe, discovery in Canada, Mexico, Asia, it's not developed in this concept of this pre-trial data dump and this ability to just kind of pull back the curtain completely to the corporate data set. So I think that tension within the corporate space is kind of playing out now across, as kind of both of you were saying, is playing out kind of across the entire spectrum. In the United States, there is just not an expectation of privacy, and I think that's true within the corporate setting. But when you're dealing with the international colleagues or a company internationally, they just don't see it that way. So it's just completely, first, makes them very fearful, but second, it makes it very difficult for us as American litigants to get what we need because they're resistant. And then obviously, as we'll talk about in the session, there's many kind of roadblocks to what we kind of take for granted here when we just call some IT team and grab some PSTs.
Sure.
Right.
Mary, ACEDS has international chapters, Benelux in the UK, and also in your international travels. What are you seeing as far as the reaction to data privacy globally?
Well, first of all, our chapters internationally, Benelux and UK, were right on it right away, and they changed processes and how they gathered names and how they gathered consent and things of that nature. So growing up with privacy and seeing it as a right and not something that's new and scary. Over here, when I brought GDPR news to folks, I felt like I was in 2005 and 2006 when I was over in Europe explaining what the federal rules of civil procedure in the United States were going to do. You'd say the data dump, you need an electronic evidence data dump, and the audience would just big eyes, deer in the headlights. Same thing over here with the GDPR and the potential fines and the short period to notify about data breach. It's more of a fight or flight, and so I saw a lot of people who just did basically nothing, and then I saw some people take some real interesting turns commercially to make sure that they could maybe bring technology in country if they were from the United States, knowing that we weren't, let's say, on the good list in terms of compliance, that they would do some different things there and I think you saw Microsoft do the same thing with where they started a concept called data. I had never heard about this before. Data sovereignty, that you know where your data is. So even though shards here and there, or data all in one country or all in one region. So I saw a mix of things, and I have to give a shout out to Katie Saylor in the front row, because without Katie, we wouldn't have been able to get our GDPR act together at ACEDS and the Barbary Group. So Katie, you might get questions later.
That's scary.
If we look at this slide that we've got up right now, and my apologies for the contrast there between the blue and the black, that was unintentional. That is actually a link to a report that Alan and I worked on during our 451 research days. And it is entitled Not Just the NSA and the USA, and it deals with government data demands around the world. And it was very interesting because at the time of NSA Snowden, even before that, the Patriot Act, and then of course you fast forward to the whole GDPR debate that, although it became effective last year, it was actually approved 2 years before that, and the debate was a multi-year debate. But basically the general concept, as Sean and Alan and John and Mary have noted, is the United States is seen in many ways as the wild, wild west of data privacy. Now, we do, as you all know, have data privacy regulations, be they HIPAA, be the FTC enforcement actions on data breaches, but there's also international data demands. This report we did on Vodafone was based on Vodafone's disclosure report, where a list of nations from all over the world, including the Democratic Republic of Congo, Kenya, South Africa, Tanzania, Australia, New Zealand, and then of course the EU as well. 14 member states of the EU were making data demands on Vodafone. Verizon puts out a pretty comprehensive transparency report as well, their data breach incident reports. So these reports provide some interesting reading to show you that it's an international issue, not just a United States issue as well. But as far as Microsoft went, as we mentioned earlier, February 27th, there were the oral arguments before the US Supreme Court. We are all waiting with bated breath, and one of the reasons this date was selected was because June, as you know, is when the Supreme Court turns out its biggest decisions. We were expecting a landmark case involving Microsoft, and Judge Francis, who issued the initial order in Microsoft, was there for the actual readings and the actual oral arguments. And it was all exciting, and then nothing really happened. This list is some of the amici, the amicus briefs that were filed both at the Second Circuit and at the US Supreme Court. This selection is interesting. Rarely do you see Fox and NPR agreeing on anything. And of course, Amazon, Apple, eBay are all competitors. Turning it back to Alan, from the corporate side, as far as issues as data privacy, Microsoft case goes, and also the GDPR, what sense do you get from corporations that data privacy is becoming a bigger issue globally? And we've already talked about how some companies are not really gung-ho as far as preparing for the GDPR, but is it going to become a bigger issue for corporations themselves?
Oh, it's definitely, I mean, it's going to become a bigger issue. I don't think that's in question. I think it's, the risk of repeating myself though, I just don't see it high on the agenda here with the people I work with in the US. I just don't see it. I mean, and you know, you mentioned HIPAA there. I mean, I've worked with people in healthcare, you know, big names in healthcare. They are definitely not HIPAA compliant. I mean, they are definitely not. But there seems to be an attitude that, you know, if we get caught, we'll sort it out. I mean, it's terrible to say. In Europe, no, there are fears, and I think Mary alluded to it. I mean, the scale of the fines for GDPR are basically on a percentage basis, right, of your revenue. I mean, that's terrifying, you know. So there certainly is real interest there. But I think it's more than that. I think there is just more of a push from the public, frankly, to no, this is not okay. You can't use my data this way. I mean, I think it's just more of a public issue. And I don't want to get too political about it, but I don't think there's that much division between the political parties in Europe either. I mean, there's quite a consensus, if that makes sense, over there. But here I don't, and I do a lot of work with technology vendors from, you know, sort of the size of Microsoft. I mean, they have been a client in the past, Microsoft, down to little startups. And in the broad, what we might call information governance space, you know, that sort of area in tech, it's a tough sell. It's a tough sell, and it's a small niche. It's a tough sell.
Alan, it's no surprise that many of the amicus briefs at the Second Circuit and at the Supreme Court were filed by U.S. tech companies. And there's been the fear for years, because of the alleged lax attitude we have in the U.S. toward data privacy, that American companies are really going to be hurt, along the lines of, hey, you better not put your data with an American company because Uncle Sam will be there with his prying fingers to get it. Are you seeing that internationally, and are American vendors really getting knocked over the head on this?
Yeah, they are. I mean, but part of that is because they just happen to be the biggest. I mean, you know, if you add Google to that list you have up there, you add Oracle, you add IBM, and I mean, you know, they're all American companies. And they're the ones holding the data. So I don't know that it's necessarily anti-American. I think it's just the fact that it happens to be American companies who are holding the data. I think where it gets complex, though, and where they're very concerned is, to be the devil's advocate here, yes, they have been very lax. I mean, you know, Google, I mean, it's just repeatedly been caught out. I remember early in my career, and I'm sure this being an e-discovery session, people understand it, when Google continually said in their sales and marketing that all of your emails in Gmail were fully encrypted all the time. And the point was, well, then, if they're fully encrypted all the time, how can you possibly make recommendations and do analysis on it? It's not possible. You can't do analysis against an encrypted hash of nothing. It's not possible. And of course, it wasn't encrypted all the time, and there were multiple breaches of it. So there is a reputation issue there for sure. And again, to Mary's point, some companies, Box, if you've heard of Box, they're a file sharing company, they have gone a long way down the road of data sovereignty, so that, you know, your stuff never leaves Germany, never leaves France. But, and this is the big but, cloud computing ain't that simple. Even when you say that, and I take Box at their word, I'm sure they're trying to do it very, very well. Just about any cloud computing system, if something goes wrong or there's a peak load, it will default over to Amazon and and you have no idea where that data's gone. It's almost impossible in cloud to keep something locked into a particular region. Almost.
Thank you, Alan. Turning over to Sean. What are you seeing at FTI as far as data localization, the topic that Alan brought up, as far as keeping data in one place? And are you seeing a backlash, at least the attitude when you travel internationally or talk to international clients? Is there this, hey, don't put your data on American servers attitude?
The latter is definitely true, particularly with respect to global companies that compete in other areas of the world other than the U.S. Even if they are headquartered here in the U.S., they are cognizant and very much aware of the lack of privacy. And Microsoft kind of introduced all of us to this idea of data sovereignty and segregating data. Whether or not it was completely accurate is up for debate. But since then, the companies that I've worked with have certainly made the concerted effort to segregate data and be mindful of it. But there's also, on the flip side, to a point John made, there's this American attitude that we don't need to comply because we're American and we're going to wait and see how bad the fines are going to be. And, is the fine truly enforceable to me here in the U.S.? So I think it depends, but there definitely has been the attitude that don't put your data, in a U.S. server. And I think that's why we saw Microsoft and Amazon, make such a big shift and change their marketing and, in some places change their branding altogether to show that they were more of a European, or in some cases, Asian and Indian facing organizations.
John, you seeing any of that anti-American sentiment as far as where data goes and on whose servers it goes?
Well, I guess my perspective is a little different because I work really with the end clients. So I think a lot of these discussions deal with, kind of the IT infrastructure and the decision making there. When I'm involved, it's a lot less of kind of discussing this at a theoretical level and figuring out more where is it. So, I think the points people were making earlier is the hardship for us when we're in the seat of trying to help these clients find this stuff, is they think it's as secure as can be, or it's sitting in some place somewhere, and then we try to go look for it, or we try to work with their vendor partner and they can't find it, or they don't know really where it is or kind of how it's configured. So we're chasing things around with a pretty incomplete picture and understanding of what they're doing. So what we're trying to do on the back end is just piece together how we get what we need. And it's not always that difficult. I mean, sometimes it's just we're using like the whatever the application is, we're just putting inputs into it and it's giving us the reporting we need for production. In those cases, we don't really have to get into those details. But in others, where we have to figure out where the underlying data is, that's when those challenges come up. So for me, it's, I don't get involved so much in, other than kind of best practice discussions like what we're having here, I don't deal so much with, where the data is as how do we figure that out and find it.
Sure. Mary, what are you saying?
Well, we used to have some workarounds, and I'll use that term loosely. Sometimes the workaround was to send a team over just to go grab up the data, no matter what jurisdiction it was in, no matter what the privacy rules were, and that type of activity I've seen dramatically reduced. And before we used to do things, some of us called it the friends and family way to get emails. So if you had email in the EU, and maybe they were sending email to the United States, you would collect it in the United States because it was over here, and then we didn't have a problem collecting it. But with that extraterritorial reach, we're not seeing that as much, and people are actually thinking twice about practices that were, shall we say, expedient would be like a euphemism for what those practices are. So I think there is a bit of a reckoning of, oh my goodness, how, if this is real, to your point, if this is going to be enforced, and we're going to take a reputational hit or a monetary hit on it, what are our alternatives to get done what we need to get done as attorneys, either in criminal or in civil court or for regulators?
We talked about United States v. Microsoft, and then how the exciting denouement was coming, and then they passed the Cloud Act. Historically, as many of you know, the U.S. Congress and the U.S. administrations have have taken somewhat of a hands-off approach to technology. The first United States v. Microsoft on antitrust grounds being a notable exception, but the idea was don't kill the goose that laid the golden egg. Tech is a driver of the US economy, don't overregulate it. It is tough to get anything through Congress in 2018, and the idea that the Cloud Act would make it through was fantasy to a lot of people. The idea that you could even get a committee hearing, get it out of committee, get a vote on it, just seemed as though it were impossible. Lo and behold, there is another way to do it. You just slip it into the omnibus budget bill on page 2044, I believe, of 2200, and there you have it. The president signs it. It is law. What was interesting as this thing was going forward, when Microsoft v. United States became United States v. Microsoft, it gets to the Supreme Court, tech and, for lack of a better term, big data privacy organizations such as Public Knowledge and the Electronic Frontier Foundation were unified on the side of Microsoft in this case. The data privacy organizations for data privacy reasons, the US companies filing amicus briefs out of fear that it was going to hurt their businesses, and of course they made the argument that it was an unfair legal intrusion. So the Cloud Act comes, it goes in, suddenly the marriage has a great schism. Big privacy, Public Knowledge, and EFF are still against the Cloud Act, but the Cloud Act had support of big tech. Mary Mack, when you look at this schism between the privacy organizations, do you think that there is going to be general acceptance of some of the provisions of the Cloud Act? For instance, one of the problems that the privacy organizations have is that now international foreign governments have the ability to file to get data from United States servers. So it's sort of the opposite of what was going on before.
Like, how dare they?
Something along those lines, exactly.
Like, what's good for the goose is good for the gander. I don't think that that is something that's very well known. That that other governments can come and get data from United States citizens. I think the first high-profile case of that, and we are going to see privacy become quite popular. That's my prediction there.
And you know, one of the things that happened in the Microsoft case was the argument on the government's end that the Mutual Legal Assistance Treaties, or MLATs, were just too slow and cumbersome. Basically, you go back to that whack-a-mole thing. If we have to go and file an MLAT and there's an agreement with another nation to get the data, the bad guys are going to move the data. Has anyone had any experience with using an MLAT before, having to try to do discovery based on one?
I have not.
And that goes to show you how seldom they are used. That Republic of Ireland brief that you see on there was the argument like, hey, we have an MLAT with the United States, you can go ahead and do that. So the Cloud Act really puts a new spin on things. We're about to take a deep dive into the General Data Protection Regulation, but before we do, any questions on anything you've heard so far? Yes, sir.
I was just wondering if you could describe what the Cloud Act says. I mean, I'm sitting here thinking about the old legal term in rem jurisdiction and wondering how this all plays out. Because in law school, I remember there's if you're in Massachusetts, there's territorial jurisdiction of the Massachusetts courts and legislature. But if I'm carrying a nuclear device around, the Nuclear Regulatory Agency has jurisdiction over that no matter where I am. When I have emails sitting outside the jurisdiction of the United States and in Europe, and they say, these are our servers, we're not going to let you just come and grab everything. That seems like an in rem argument that we're trying to make. Well, those emails are subject to our laws, so we ought to get them. And they said no, right? So does the Cloud Act attempt to remedy that by extending jurisdiction? I don't know what the Cloud Act does. I'm hearing you talk about it, but I don't.
Sure. I can take that one, or anyone else want to jump in? As far as the specifics on it, so we've already talked about the fact that it sets up a procedure for international agreements on data. And you don't have to go through the cumbersome process of going through an MLAT. You merely go and you can negotiate with approved countries. and there's a procedure going through that list, and they will certainly develop regulations interpreting it. One of the things is
Treaty, is it Congress can say what they want, but they still need a treaty, right?
Well, they're calling them agreements under the language of the Cloud Act. The governments can go into agreements for data sharing. And once again, as Mary pointed out, you're really having a role reversal here, because under the 1995 directive of the EU and currently under the GDPR, we are not seen as having adequate data protection. So the idea is, are these other countries going to be having adequate data protection? So we are now, the shoe's on the other foot. We're now saying, all right, are you an adequate country to enable you to come in and get data from US governments? I'll read you some of the language from it. You can get these agreements. However, the Act provides that a provider may move to modify or quash the legal process where the provider reasonably believes the customer or subscriber is not a US person and does not live in the United States. And, it's not an or but an and here, the required disclosure would create a material risk the provider would violate the laws of a qualifying foreign government. So you can make these agreements, but that qualifying foreign government language is basically the 1995 directive of the EU and the GDPR. Shoes on the other foot now. Also, these are executive agreements that are going to be made between the United States and these qualified nations. So you're not going through a formal treaty process where you've got to have a treaty ratified by Congress. You're going through and having executive agreements. Not, it's sort of like comparing apples and oranges, but not unlike what you had under the Safe Harbor, where that wasn't a treaty ratified by Congress, or then even the Privacy Shield after that. And of course, we could talk about Mack all day long, and because he's already filed the first complaints under the GDPR.
He filed within, what, hours, minutes? Yeah. Facebook, Google, who was the other one? Amazon, yep.
On to the GDPR. By the way, any more questions before we do our deep dive in GDPR? Okay. What you see on the screen are the different chapters of the GDPR. John is going to give us a deep dive into Chapter 5, which is very important to any e-discovery practitioner. And one of the reasons we've described this session as from an e-discovery perspective. All the data privacy issues we've discussed so far today affect e-discovery. We're going to really get into the weeds a little bit on how they affect e-discovery. But as you can see, you've got 99 articles here, plus, may we add, 173 recitals. Just some light reading for you. If you go on to this one, we've talked about the fines before, and this gives you a deep dive into what is going on with the fines. There are basically two tiers of fines under the GDPR. And you'll see on the screen, one is the fines that are up to 2% of turnover. Sean mentioned turnover earlier, the Queen's English for the American term we use, revenue. But as we go on to this, if you have fines up to 10 million euros and 2% for certain violations, it then goes up to the one you've heard about, 4% of annual revenue, or 20 million euros, and then that is whichever is higher. And so that could be a catastrophic fine, and that's why you've heard so much doom and gloom over the fine structure. Because if you're a large corporation and you are found by the local data protection authority to have engaged in some really egregious conduct, then you could be in for a world of hurt. But one thing we should consider on the fines are these fine factors, and these are located in Article 83 of the GDPR. If you slip up and you let some PII get out, or personal information, into the GDPR, it is highly unlikely that you are going to get anything near a fine of 4% of your annual revenue. And if you look at the list on here, you can see, basically, are you a nefarious repeat offender? Have they had to call you out on it before? Was it intentional or negligent conduct? What kind of data did you let get out? the degree of cooperation with the data protection authorities. And so if you look in Article 83, take a look at these various factors the data protection authorities are going to consider, because that will have a real impact on whether you or your clients are going to face these liabilities. John, you want to take us on a tour of Chapter 5?
I will do my best. So what the panel had asked me to kind of talk about is what really I do day in and day out. So as we talked about at the beginning, I'm e-discovery counsel at Mint. So where the GDPR comes into my practice is not so much, and we talked about this in our prep calls, not so much on the best practices for companies. We have privacy counsel that advises on that, and there's a whole host of vendor partners and lawyers that really focus on integrating and implementing the GDPR into your everyday privacy policy. You've probably seen a bunch of like, why am I suddenly getting all these requests to reaffirm that I'm interested in the mailing list? That's why. That's not what I'm focused on, and what I thought, since we were talking about e-discovery and the GDPR today, I could talk a little bit about where I think the GDPR comes into play in civil litigation most frequently. So I'm not going to cover criminal lit. I apologize. I don't do criminal litigation. So really my expertise and understanding of the GDPR has been focused on transfer options for civil litigation. So I'll walk through Chapter 5, and it's actually pretty well laid out. If you just read this, it's pretty brief and easy, but then unfortunately there's all sorts of caveats and considerations, and we have a lot of historical knowledge of how things can kind of go off the rails based on the earlier directive that, a lot of that's left unchanged, and we'll go through some of the updates and some of the insights that I and others have been talking about with respect to how the GDPR might change our transfer options. But just to take one step back from that, I think what's so challenging for litigation in the United States and pretrial discovery specifically in civil litigation is that that's not what the GDPR is about. This isn't about discovery in America. It's really about personal privacy and consumer privacy, and making sure that that data is protected by the companies that do have kind of transcontinental and international operations. So we're kind of shoehorning e-discovery into regulations and rules that deal with something completely different. And in fact, I don't think in the actual GDPR, and you guys can correct me if I'm wrong, I don't think the GDPR refers to pretrial discovery at all. The working group in their recent guidance, and I apologize, I didn't bring a link to that guidance. I'm happy to send it to you and the group can get the email. But there is recent guidance from the working group on some of these transfer options, and there they mention pretrial discovery specifically. But in the GDPR itself, it's nowhere to be found. And I think that's why these transfer options that we'll go through and kind of the conflicts that arise are here, because it wasn't designed for that process. Why? Because as we talked about at the beginning of the program, this is not a concept that's familiar to folks in the EU. Practitioners and litigants and consumers and everyday people don't see the trial court approach like we do or on TV. I mean, I think when I talk about e-discovery to people that aren't even lawyers nowadays, they've like seen some show where someone's cell phone had the smoking gun on it, and then they're like, oh, that's discovery. So, even in the United States, people that have never set foot in a courtroom kind of get the concept of discovery. Very different in Europe, where there's just not this pre-trial phase where you send these crazy demands for every single shred of evidence that's ever existed, and frankly with no real tether to relevance beyond likely to lead to, I can't remember the exact phrasing in 26, but it's the claims and issues of the case, and a lot of the state equivalents still have the reasonably likely to lead to discoverable evidence standard, even though the feds have changed it. So very different.
Quick question for you. You were talking about how discovery doesn't appear in the GDPR, but I think you're going to get to it in a minute in the litigation exception.
Right.
I heard from a very sophisticated member of a legal team of a very sophisticated corporation that shall remain nameless. Well, we don't have to worry about the GDPR for e-discovery. There's a litigation exception. Have you heard that from your clients?
Well, so I think that, and we'll talk about that as we get to that slide. But to jump ahead, there's various ways that the GDPR lays out as possibilities for data transfers to third countries. So anyone outside of the EU or who's not an accepted private, has a significant demonstration of privacy considerations that the EU deems sufficient, that's considered a third country. So obviously the United States, for all the reasons the panel has talked about, is not considered, at least currently, and probably not in the very long foreseeable future, ever to be considered privacy adequate under the GDPR. So in addition to those countries where that adequacy decision exists, and we can look at those slides, there's a number of other options for when that isn't the option. And one of those options, called derogations, is this idea of a necessity for a legal claim or a legal interest in another country. And that guidance from the working group does suggest that that is one of the options for discovery. But it doesn't like absolve us, and that means just send me every employee's data, right? It can offer you a transfer option, but like everything else under the GDPR, you still have to demonstrate that it's narrowly tailored, that the private information couldn't have been more anonymized or omitted from the production. So it does potentially open the avenue to a transfer, but that doesn't mean that you then just do what you would do in the US and say, send me every email in the company. You're still looking very closely at the remainder of the chapter to make sure you're in compliance with the overall spirit, which is you're protecting personal information to the broadest extent possible. In addition to that, what's new is that prior to the GDPR, the directive had similar language about this, but it allowed the varying countries. Remember that under the directive, there's kind of two deciding groups, I guess, and feel free to put it in a better term, but you've got the kind of EU as a global entity under the directive, and then each of the member states are implementing their own adopting and not adopting various provisions of that directive. So you could get to a Germany, for example, specifically said pretrial discovery does not count under the litigation exception. So that was under the directive. The GDPR is a little different since it's going to be implemented globally. So I'm curious to see how that will go. I don't know if states like Germany or France will attempt to use their blocking statutes to shoehorn back out of the litigation exception, but from the perspective of the working party, I think it's not a free-for-all, but it is certainly one way you could consider making sure you've checked all the other boxes in terms of I've narrowed this and it's necessary and we've really taken every step we could to provide only the necessary relevant personal data. I think you could use it. There's one other thing we can talk about, to think about there, but I can walk through maybe more of that if you want.
Great.
Am I answering this, or am I just rambling on and on?
I mean, well, let's ask our audience.
Yeah, just if it's like too much, just. So let's back up, because I think we jumped right into some specifics, and maybe I can set the table better with just a few general concepts that we would have great. So Article 5 is really the transfer option section. It talks specifically about when data can go to third countries. And so, as you see on this slide, it's divided into 7 articles, with Article 44, the first of those articles, laying down the general principles for data transfers. So regardless of what you're doing in terms of transfers, everything must meet these kind of very, I guess, high-level statements that are included here on the second bullet. I thought today we could focus just on 3 key categories of transfers, because these are the ones I think that come up most in my discussions about how to get data out of the EU. And those are Articles 45, 46, and 49. Each one of those covers a different option, and it's interesting, they're kind of in like cascading order. If you can hit 45, you shouldn't do a transfer under 46 or 49. Typically though, United States, we can't do 45, so we have to look to 46 and 49. But I'll tell you about each one of those after I tell you one thing about Article 48. And this is what I was going to say about the question on the derogation that allows these transfers of data when they're necessary for adjudication of a legal claim. Article 48 specifically excludes from transfer any information that's compelled by a court or tribunal or decision of an administrative authority of a third country. So a judgment from the United States on a motion to compel saying you must go to Europe and get this data, that falls within Article 48. And so in doing that, you then get kicked back into the requirement that you do this via a mutual assistance treaty, which, as I don't know if we talked about, but we're not going that option. It's not something you're going to do in a routine litigation, you know. So it really makes it difficult when you've got the court involvement. You know, getting a court order on this makes it, I think, more difficult to transfer, because then if you've got a court saying you need to go to Europe and get this, you can't then use some of these other derogations that you might be able to. You have to really follow the letter of Article 48, which requires you doing it only through an international agreement like this MLAT, or I suppose a reverse of the class. Maybe if we have an agreement with Europe, we'll have to see, but if we had an agreement with a European nation for them to come here, maybe you could rely on that in reverse to go there.
Possibly, and of course, all this was drafted before the Cloud
Right.
Act.
So
Let's ask the audience. I've asked the panel if anyone had personal experience with an MLAT, a mutual legal assistance treaty, as a way to do e-discovery data. Have any of you? And that is about par for the course, because I've asked this question at other fora, and no one's ever worked with an MLAT. I am sure there are people in Washington who work with them on a daily basis, but pretty unusual.
So the only other note I'll make here, and I think this is the, you know, so what I guess I neglected to say is, you know, this article does not prejudice the other grounds. So if all you have is an international demand from a court or an administrative authority, you can't proceed. But if you can make, I guess if you can find another source of adequacy under the GDPR Section 5, you can proceed with the transfer. So I guess that the point there to remember is, you know, if you have that court judgment, you don't want to rely on that, because that will run afoul of the GDPR. But then if you can kind of find a derogation that makes sense, which ties us back to the litigation exception, and we'll talk about that in a minute, you may be able to do it. So just remember, you know, just having, I think people think if you have a court decision or something, that's going to somehow enhance the ability to do it, but that actually makes it more difficult, I think, because that doesn't get you any other sort of ability to go behind that curtain and collect that data.
I think at least for clients that I've worked with, it's typically corporations and they're in the commercial space. So, you know, if they are so used to relying on motions to compel for their adversaries that this concept is very hard for them to get past, particularly if their GC is not a litigator, is an IP person. Trying to reverse what you've kind of beaten into their head for 10 years of, yes, let me do this, is going to be very difficult.
Right. You don't want motions to compel on this if you can avoid it.
Right.
Is there an agency in Brussels with a specific address? I mean, it's a black hole. Who administers this?
There are 29 of them.
Oh, really?
The GDPR provides for a data protection authority in each nation. And John hit on this earlier. The idea behind the GDPR is to try to harmonize all the laws of Europe, so you didn't have to deal with each individual member state. And of course, it really covers the entire 31 nations of the European Economic Area, as well as the 28 members of the EU. So you have these data protection authorities, and if any of you work with the International Association of Privacy Professionals, the IAPP, they interviewed some of the data protection authorities. And, you know, Sean, what do you think at FTI as far as dealing with these different data protection authorities? I mean, granted, we're supposed to be harmonizing all into the GDPR. It's all going to be the same. But they've got some discretion.
They have a lot of discretion. And full disclosure, I'm CIPP US, not E. So I did not do any of those interviews myself. But in the various panels that I've participated in with different DPAs, it's remarkable how much they differ in how they view their right to enforce in their local jurisdiction. You know, I think we were talking about it earlier that, you know, a lot of us were kind of suspect that Ireland would be the first to enforce, just based on how much staff and resources that they poured into enforcement preparedness. But it was interesting to see that indeed they were not the first to enforce. So.
John, some more of the nuts and bolts.
Yeah, I feel like I'm going to put the room to sleep, but I'll go to this is the good stuff, because now we're into the options. So I'll give you guys some things to think about, and I'll give you some things to consider. So starting with Article 45, this is what we've kind of been talking about, these adequacy decisions. So what Article 45 says is you can transfer this data without notifying anybody, if you are transferring it to a country that the Commission has already decided has adequate levels of protection for personal privacy data. So that's not going to apply to the U.S. for all the reasons we talked about now. And then just remember, too, there that like Article 48, just because there's not an adequacy decision doesn't mean we can't move to Articles 46 and 49. We just kind of keep going down the cascade until we find something that works for us. And so for us, we just skip right past 45, because when I'm working on these cases, we know we're not going to be able to do anything there. A couple things that I was making notes as I was reading some of the guidance I was looking at. Any existing decisions on adequacy remain in place. So, again, not going to apply to the United States, but to the extent another country has been determined to be offer an adequate level of protection, that's going to stay in place until it's amended, repealed, or revoked, or renewed, I guess. But yeah, so those will stay in place until something happens. Going forward, the adequacy decisions are only going to be valid for 4 years, and then after that they can be revisited or amended. So I think that's going to continue to kind of cripple this option for anybody. But again, the United States is not really on the list. I don't anticipate we ever will be. So know it's there, and then if you're ever practicing in somewhere else, you can see how it works there. So if we can't do 45, we move to 46, and this is a section that's about subject to appropriate safeguards. So I just wanted to call out a few of these safeguards, and I'm not going to go into huge amounts of detail. One, because they don't typically come into play, and two, there's other things to look at beyond this. But I've outlined in these slides some of the most common wording you'll see or approaches people will take when they're trying to use Article 46, and those are binding corporate rules, standard data protection clauses that have already been adopted by the Commission, or standard data protection clauses that have been adopted by one of the EU member states and approved globally by the Commission. So interesting there, what does all that mean? For us, the standard contract clauses offer basically, it's like a bunch of contract clauses that we can drop into some sort of agreement we have in place, whether it's the person that's holding the data to the vendor or some other combination of folks, however we want to set that up, whatever that contract may be. If these provisions are in that contract and it's otherwise a valid contract and kind of checks all the boxes with respect to the person that holds the data and who they're transferring it to, you can just essentially drop those clauses into your otherwise, I guess, maybe your vendor agreement, your transfer agreement, your processing agreement, whatever it is, and that should cover should allow you to do that transfer without more. We don't typically take this approach just because it's kind of hard to shoehorn these provisions into, again, a litigation contract. There's if Mints is getting the data, or if a vendor partner is getting the data, it's hard to find the privacy between the client and the person receiving the data in an appropriate way to kind of put the clauses in. But I know other people have done it, and there certainly are situations where it works. Just remember here that the currently approved standard protection clauses are going to remain in effect until they're changed, repealed, or amended. So as of now, if you've used previously those provisions approved under the directive, those remain in force. And like I said, again, in addition to kind of finding the right place to put those, you can only use these, again, kind of like everything else, you can only do the transfer if you can find another legitimate reason to do so under the GDPR. So even if you can say we have these provisions in place, you still have to have some legitimate reason to do the transfer. And the legitimacy considerations usually stem back to narrowly tailored, not otherwise possible to eliminate or edit out the personal data, et cetera, et cetera. So it kind of continues to present the possibility that you could run afoul of the GDPR requirements, even if you have the appropriate safeguards in place. So, again, an option that's out there, people do use it. We always try to kind of jump to Article 49, and I will wrap it up. This is kind of, if nothing else fits, try these. And I highlighted a couple of the real key ones that, again, apply to civil litigation, and this is the two that we really kind of focus on when we're getting these questions from our clients or trying to figure out a way to do this. One, consent, and two, as we talked about earlier, the legal claims, the necessity to a legal claim. Very quickly, consent has always been a very challenging, tricky thing under the directive and now under the GDPR. It's not consent like, I'm going to take your data, is that okay? And someone says yes. It's a much more intensive process, and the GDPR lays out a bunch of expectations, including that it's revocable, including that it's explicit consent, that it isn't a coerced consent. So a lot of those, when we're collecting data, it's typically employees of a company we represent. So a lot of those aren't going to be, I mean, there's a perception that when we're asking an employee to take their data, they don't have the ability to consent truly, and we can't let them revoke consent, because that would mean we would take the data and then they'd say, never mind. And what would we take that back from the adversary and tell the court we had to do? So consent really is still a dead end, and it kind of always has been.
Doesn't that run into problems, though, in some places like Germany, where the courts have said employees can't consent in those situations? It's not valid.
That's exactly the problem with consent. Is you've either got previous decisions from those local authorities that say that, or you would run afoul of all of these provisions pretty quickly with employees, just because you can't give, as you were saying, you can't give a consent that's not coerced, if you could get fired for not doing it. So I think people like the concept of consent, and some of our clients will still get a consent form as kind of a backup. But if you're planning to rely exclusively on consent, whether it was under the old rules or the new, think very long and hard about that. And and the other thing to keep in mind is the GDPR, because it's not pretrial litigation focused. It doesn't just mean that I'm going to get your personal data if you say it's okay. Every other email address and phone number and every anything in those emails that isn't to them, even if it's other employees or if it's their family, that also could potentially run afoul. And that'd be a lot of consent. So consent's kind of a dead end, but I think for a long time people have tried to rely on it, and I think a lot of clients are like, well, we'll just send out this consent form. Isn't that good enough? And it's a very calculated risk, and we walk them through the reasons why you wouldn't want to do that. But the challenge is, I think, with this option and every other one, there's just not a lot of great options out there. So finally, the establishment of legal claims exception, which is 49E, that's the other one I've highlighted here. There are many others, but I just tried to focus on the things that come up most frequently, at least in my practice, in the civil pre-trial litigation context. And this, I think, we're going to have to see how this plays out. But this has always been a kind of appealing option. As we talked about, though, up until the GDPR, countries like France and Germany use blocking statutes or other restrictions to say this specifically does not apply to pretrial discovery, because they did not want American litigants coming in and taking data in these ways. So those kind of blocking statutes, I don't think, you guys can comment on this too, I don't think they are going to survive the GDPR, because I don't think this is one of the provisions where the member states are allowed to change it. But I think that if we're gonna be discussing anything here, it's that question and the interplay between 48 and 49.
Right.
So because just to bring that full circle, what is 48 versus 49? 49E opens the door, I think, arguably to pretrial discovery, because we're doing pretrial discovery without a court judgment, right? The question is, does a scheduling order that allows for...
That's what I was going to ask you.
Yeah.
So those are the open questions on this. Is the guidance from the working party essentially names pretrial discovery as a permissible activity under 49E. So I think you're in the clear there. But the question is, when you're already in, so if you're involved in just kind of a settlement discussion, maybe where you haven't involved the court at all, that is, probably more likely to be fitting into this than when you've commenced pretrial discovery under a scheduling order, or when you've already filed a complaint and a response or an answer with a court. Because anytime the court issues an order, so if the court says, here's your scheduling order and pretrial discovery is due this date, your document requests and responses are due this date, is that an order of a court under this scheme? And that's, I think, where the rubber's going to meet the road on this. So, as of today, when we don't have that kind of thought leadership because everything is so new, I think we're clear. But the minute someone somewhere says that this, that this kind of a thing or some minimal court involvement equals something that would go back into 48, this avenue is then likely shut off. So as of today, I think you could do it for pretrial discovery absent a bunch of kind of court involvement and going in with a motion to compel or some other thing. But keep your eye on this, because I think that's going to be where Europe will get back at us and say, no, you can't do it if there's, once you're in the pretrial phase under a court supervision, that is different than what we're referring to.
Yeah, I certainly wouldn't try this if you have a special master on discovery or anything like that.
Right, and the more if you're exchanging document requests in a state court and there's no requirement that anything be filed with the court, maybe that's better. But if you're in a federal court where you're sitting before a sophisticated magistrate and they're issuing all sorts of decisions and schedules and guidance, think about it, because I do think that would arguably fall back into 48, which, as we discussed, would require you to follow a more formalized process. So that's kind of the high points on those articles. I had one other slide on something that's new, but another bad option. So does anyone have questions on any of that, or does anyone else on the panel want to jump in?
From the floor, anyone got any questions on these Article 5 provisions for international transfers before we get on to a panel discussion about some possible best practices? Great.
Everyone knows what to do now.
Right.
Don't get data from Europe. So quickly,
Sure,
49, they added one new exciting thing. So I'm excited about it because it's actually new language over the other one. It allows for this concept of a one-time transfer of a limited amount of data, which again sounds great, except you are supposed to disclose it to the commission. So I don't think, first of all, we don't really know what a limited transfer means or what a limited amount of data is. You're supposed to disclose you're doing this and give a bunch of assurances about how you're protecting data, and that all goes to the data commission, or to the commission or whoever. So we try to steer clear of anything that requires us to provide any sort of insider notice to the commission, because then you're inviting them to look closely at what you're doing. So I think time will tell on this, but I don't think this is going to be an option pursued much for pretrial discovery. And quite honestly, I think we're going to continue to face the issue we had under the directive, which is there's never really a good fit because it wasn't designed for this. And the European Union and its member states don't want to encourage large-scale global e-discovery. So, we'll continue to sojourn on. These are some of the considerations we have when we do this. Talk to a local counsel if you're really getting in the weeds on this. Consult with your clients as to what they've done before, and vet this with others in the industry, because we're all learning this together. And I think as of now, we don't have, 100% security or kind of comfort on any one option.
Thanks, John. And that is an excellent segue into some GDPR best practices. And we see that John has already claimed one off the list. Mary Mack, as you see the list of GDPR best practices, anyone in particular stand out at you as something we ought to take to heart?
Well, I think I'll go with number 3, David. Number 3 is establish a data breach action plan, including notification procedures. And I think a lot of the regulated industries have those breach plans in place, but I think a lot of unregulated companies do not. And so I think that would be one area that you could shore up for yourself that has benefits beyond the GDPR.
Excellent. Let the record show that we always try to practice church and state in educational programming, and Mary Mack has hit a home run on this, because if you look at number 10, that was a softball I lobbed over the plate for her to choose to tell you about ACEDS resources. She has declined because she believes in education, not marketing, from these podiums. So thank you, Mary. Yes, question?
At what point does failure to comply with GDPR potentially turn into a breach? Because some of these are reading like breach notifications related to things like HIPAA or New York DFS.
You have asked an astute question. And, one of the big debates was the entire 72-hour notification period. And one of the big responses to that is, what do you know about a data breach after 72 hours? Alan Pell-Sharp, data breaches are all over the world. Do you think anybody knows anything after 72 hours?
Well, it depends what the breach was. I think, that comes to, what is it, number 4 there? Retain the data protection officer. Who on earth is that? What is that? And is that a legal person? Is that an IT person? Is it an info security person? Information governance? I don't know. The list goes on. But I mean, it's near impossible, to be frank, right? I mean, you have email servers in the cloud. you've got people with messaging apps, you've got business applications, you've got some on-premise, you've got some in another cloud. So who is this data protection person? How on earth are they ever going to really know until it's too late? I mean, point there is data breach, I get it, but protection, it's really hard to do. I mean, it's incredibly hard to do, and I don't think it's laziness. I think it's just the sheer volume of data, the sheer number of applications that are running in any company today, public or private. I don't think anybody can really is in a position,
especially with the volume of nefarious actors, you know, both commercial and state, that are looking into, you know, U.S. data, particularly, you know, sales and marketing lists to you know, get that access. I think to Mary's point, you know, having a breach plan in place is great, but maybe also educating your employees, particularly those that govern the data and work with the data, to maybe not use the breach word right away. Maybe say that it's an incident. Buy yourself some time, maybe. But yeah, to your point, you know, the DPO, it's a big question mark, at least in my mind right now.
You've heard it here first. Avoid the B word.
I think that the idea of a data protection officer is to have a person whose responsibility includes this, and it's supposed to be a person that can report up into the C-suite or the board of directors, and I don't know, it's the analogy that's coming to me is from my early e-discovery days, the one throat to choke, if you will, a place where people can ask about their data and would be responsible for reporting a breach. So I think that's the intention, and who's going to do it? CIPP is, you know, having a good run on educating people to exactly to fill that and how it'll be filled. I think it's still early and what they'll do and how they'll do it, but the larger companies are appointing people, and these notices have to go somewhere.
Right.
And if it's diffuse, you know, you won't be able to do anything with it. You won't even know if you're having a breach. Yeah.
And Kamal, you make a great point also on data breaches, because there is the domestic issue as well. I mean, we talked about the Wild Wild West in the U.S., and we also mentioned the Federal Trade Commission. They have been very aggressive on enforcement actions, and, you know, Sean, you mentioned the nefarious actors. There was the long-running case of Wyndham Hotels, where the FTC went after Wyndham for violations of the Federal Trade Commission Act, saying it was a deceptive trade practice. And Wyndham is like, wait a minute, we're the victims here. And the FTC goes, oh, no, you're not. If you make those assurances, you're protecting the data. And then you've got different states in the U.S. with different data breach requirements. So it's a complicated issue.
Kamal raised a good point about compliance with the New York State Department of Financial Services, particularly Rule 500 with respect to cybersecurity, which I think goes into enforcement in September 1st or 3rd, I believe. And I think, you know, we're starting to see locally on the state level, and then, you know, even more specific sometimes in this case, you know, in a specific industry, that the consumers are starting to demand that their privacy be taken seriously, and, you know, they are expecting that enforcement happen, you know, at some regulatory level. And I think it'll be interesting to see what happens in New York as this is enforced. You know, it is the trading hub for the U.S.
Sean, to follow up on what Alan was mentioning about the data protection officers, when you talk to companies, are you seeing a lot of them that have appointed a data protection officer? One choke to throat is to choke, as Mary would say. Sorry about that.
You know, just given my background, most of what I've specialized in is in regulated spaces. So yes, I have seen a lot of my clients appointing DPOs, and some of them even going a step further as to having segregated their DPOs by business unit or operating company. So I think that's just a nature of who my clients are. I don't know if that is indicative of the space generally.
Gotcha. Well, I've got you here. One on the list you'd like to point out is more important than perhaps some others?
Educating your team. I think being mindful that it is, data is a company asset here in the U.S. Even though it is a private asset in the EU, I think educating your team on those differences and making sure that to the extent you have appointed a DPO, you have put a breach plan in place, that there's a meaningful and thoughtful communications plan and training plan around that, so that all of your employees are acting in good faith.
Gotcha. Alan, you talked about data protection officers, the difficulty there. Anything else from the list strike you as somewhat important?
Well, actually, I was going to agree with the educate your team thing. I mean, I come at it more from the technical aspect, but I mean, if you ever get into any of the discussions around information governance, it's not a harmonious discussion. The IT security people are having one discussion, legal's having another. I think that's where a lot has to be done, because I think that's actually where a lot of this goes wrong. I mean, I can't name the client, obviously, but I mean, I guess it was a breach. I don't think it was terribly serious, but it was a highly regulated industry, and somebody installed a new search engine to find things, to find files. Well, if you think about it logically, a search engine has to be able to get through the security, because it can't work otherwise. So, of course, they disabled the security to all of the business applications. And long story short, nobody felt they'd done the wrong thing. There was a big argument, but there was a business to be run. The business needed to fix a problem, and they did. And I think you take a large organization. I mean, I worked in healthcare once, and they had 15,000 plus, but 15,000 for sure, silos of data and information. How do you get your hands around it? It's just so vast.
I mean, it's a good point, Alan. Having those different groups being, kind of siloed is kind of a recipe for disaster. So to the extent that you can encourage that cross-functional collaboration, bringing everyone to the table at the same time so that people are aligned and doing, what's best for the company. Each group may have to make some concessions, understanding that, but engaging in that dialogue in a way that, you're collaborating and really trying to reach the best outcome for your client, which is ultimately your company, I guess.
Before we get to final questions and wrapping up, we did want to let you know that if you love the GDPR, wait, there's more. The e-privacy regulation is currently under consideration, and as you can see from the slide, it is basically a companion to the GDPR dealing with electronic privacy and all the e-services that you may be using. Obviously, the GDPR covers a lot of that too, so that's why it's a complement to the GDPR. And the draft was done last year. They're still working on it, so we would encourage you to follow the e-privacy regulation as it meanders its way through the EU process. Before we give you a closing thought, any last questions that anyone would like to add? Yes, sir.
I'm wondering if you can direct us to that so-called EU process. I'm still sitting here confused, wondering if I run afoul of some company or some law in Germany, who's going to come after me? Who's going to enforce it? Who do I talk to? As opposed to France or Luxembourg or somewhere else.
Yeah, the European Commission has a list of all the data privacy authorities, data protection authorities, I should say. I have it. I'll get it to you. It's you can go to europa.eu and it lists the name of the data protection authority, the email address, the contact information, all that, and each one in each of the member states.
But if you violate a member state, it's Brussels, EU that comes after you, or the European Union, European
Data
Commission?
Protection. Again, correct me, anybody jump in, but it's the data protection authority in that jurisdiction, and that's why some of these are interesting, because if you are a corporation who is doing business or marketing to EU data subjects in multiple jurisdictions, they can file in multiple countries.
And you don't need standing as like an individual. You can, like you do here for the most part with privacy actions, organizations can file on behalf of consumers, which is what Mack's Schrems did. So it is going to spawn litigation, definitely.
All right, closing thoughts from the panel. Why don't we start with Sean Kelly?
Closing thoughts. I guess I would just highlight the importance of making sure you have a cross-functional team that's looking at the issues and setting up your breach plan, your action plan.
Thanks, Sean. John Thomas?
Don't conduct discovery in Europe. That's not helpful. I think for us, our discussions always center around how do we narrow this? How do we treat this as gingerly as possible? It reminds me of the comment you made earlier. You're not going to get a 4% of your gross revenue fine if you're collecting 2 email boxes and you're doing your best to narrow that using search terms on site and you're working with the local. Just build the most reasonable possible case for yourselves. Do a very close look. Narrow that discovery. Never agree to anything that's a broad-based European collection approach. I think you can get support from courts and from documentation that we've put together to resist those kinds of efforts. But if you can't, you can't. Try to make your efforts in discovery, because discovery is very different than all the other parts of the GDPR. But when it comes to discovery, narrow, careful, reasoned. And I think if you do those things, and especially if you're working with someone local or you're doing a lot of the data processing locally, you'll be okay.
Mary Mack?
I think taking privacy as a must-have in the design process of new things, I think that would be one thing, and the know your data. So if we're talking about electronic evidence, we've got the original evidence that you're doing an intake with. You're probably copying that onto servers. You're going to index it. You're going to maybe batch it and code it. So there may be some batches out there, and then you're going to produce it. And at each stage, you're going to back it up somewhere. And then maybe have business continuity and disaster recovery. So knowing where all the pieces and parts of your data is, so that if somebody does ask, what kind of data do you have on me? Or I want to be forgotten, I want to invoke my right to be forgotten, you know exactly where to go and where things are.
And the final word from Alan Pell-Sharp.
The final word, wow. Well, yeah, I think what's really interesting here is in a sense that sort of, in my tech world, the cloud's just so yesterday. The reality is, obviously it's not, it's a big deal, but the fact is, in Silicon Valley, if you're going to do insider trading, there's no way you're sending emails to one another. You're using auto-delete messaging apps, if you're going to be shifting money around, you're doing it with cryptocurrency. There's just so many ways now to just circumvent. And I think that's sort of the next frontier, because I have to say, sadly, I think that's much bigger than people realise. With Discovery, I'm not an expert, but I did read all of David's research thoroughly when he wrote it. I think we even had these discussions at the time. That you can get into the email server, but the truth is probably elsewhere, and you can't access it.
Thank you, Alan. On behalf of our hosts at Suffolk Law School and the ACEDS chapters around the United States and overseas, also our panelists, Alan Pell-Sharp from Deep Analysis, Mary Mack from ACEDS, John Koss from Mintz Levin, and of course Sean Kelly from FTI. We want to thank you all, and of course our sponsors, Extero, Q Discovery, last and absolutely not least, our friends at Compliance Discovery with the cupcakes and the margaritas. Let's go have some fun. Thank you for joining us.